So I'm sure from both these standpoints.
So we're very glad. We are very glad, and I hope we meet your audience's expectations.
I'm sure. I have no doubt, sir. You're being very humble by saying, but I'm sure. I don't think there's any doubt on that. Good afternoon. It's my honor and privilege to welcome you to the weekly Saturday Solutions from BW Legal World. BW Legal World is a 20-month-old community for the legal and business professionals. We are at the intersection of law and business. What happens in business should impact law, and of course, law does impact business. BWLegalWorld.com has been around for 20 months. In August, we bring out the inaugural print edition of BW Legal World. It's a 250-page issue. Ashima Ori has edited it. For the last 4 months, we've been bringing issues that impact the community, that impact all the stakeholders in business and economy. And today we are discussing a very important and a basic issue, the fundamental principles of contract drafting. I think in the last 17 months, because of COVID, a lot of business relationships have come under strain. Contracts have come into play, and hence this issue takes a very important place in how businesses work, how individuals work, how entrepreneurs work. Let me introduce today's panelists. We have a very eminent set of panelists who joined us, who will take us through the basics and fundamentals of drafting contracts. Let me introduce Mr. Lalit Kumar, who's a partner in J. Sagar and Associates. Welcome, Mr. Lalit Kumar, to the BW Legal World Saturday Solutions. Let me also introduce Ms. Akansha Joshi. She's a partner in economic law practice. Welcome, Ms. Joshi. Let me also introduce Mr. L. Badri Narayan. He's executive partner in Lakshmi Kumaran and Sridharan Associates. Welcome, Mr. Badri Narayan. And last but not the least, we have Mr. Tariq Khan, who's a principal associate with Advani and Associates. Along with me for most part of this webinar or discussion, I'll have my senior editorial colleague, our managing editor of BW Legal World, Ms. Ashima Ori, to take forward the conversation. We start by requesting Mr. Lalit Kumar for his opening comments. Why are contracts even more important than before? And give us what has changed in the last 17 months about contracts. Of course, the fundamentals remain the same. You'll have to unmute yourself. Yes.
Sure. Thank you, Dr. Batra, and good afternoon, everyone. I'm very happy to be here. It's a very important question. I think not only in last 1.5, 2 years, as you rightly said, contracts is the most important thing when we do anything related to legal aspects. But in last 1.5 years, as you all know, everyone has gone virtual. And especially when the pandemic started, I mean, there was helter-skelter to find even provisions relating to post-mature. How will contracts be, whether the contract will be said to be breached if someone was not able to perform because of the post-mature and uncontrollable events that were taking place and that were unfolding. And of course, when we negotiate now in last 2 years, 1.5, 2 years for sure, everyone has did virtual negotiations, meetings, but surprisingly, in my view, the contract drafting hasn't got affected that much as far as working and negotiating of contracts are concerned. You have very rightly said that the fundamental and the principle of contract remain the same. But however, people have become very cautious now, especially when it comes to situations when contracts can be terminated. Just as an example about insurance contracts, I mean, all insurance companies are quite with a lot of insurance claims, and I'm told that they are now re-looking at their insurance contract also to see they cover all these situations very carefully and very, covering all aspects very clearly so that both the insured and the insurance company can enforce the contract rightly to cover situations like these. So that's what I feel to begin with. And of course, as we move along, we'll share more perspectives with the audience today. Thank you very much.
Thank you, Mr. Lalit Kumar, for your opening comments. Let me bring in Ms. Akansha Joshi for her opening comments. Ms. Joshi, your opening comments, why contracts have always been important and they will continue to stay important, especially Mr. Lalit Kumar talked about force majeure. In the last 17, 18 months, we've heard this term much more than ever. So tell us, why do we need to focus a lot more on contracts now than ever before? Ms. Joshi? I think we lost her. I'm sure she'll be joining back. But let me bring in Mr. L. Badri Narayan for his opening comment. Mr. Badri Narayan.
Thank you, Dr. Batra. I think I always see this contract as a risk allocation document ultimately at the end of the day, right? So I kind of see some parallels between what was there in, say, 2008 when the economic crisis in the US unfolded. I used to be practicing at the time in the US. And right now with this pandemic. So there's a heightened amount of risk realization during a period of a pandemic or whenever there's an economic crisis. So even on normal transactions, you're trying to find areas which can become risky or which can go out of hand. And typically it goes out of hand because many times what you're doing is not in your control. So one of the main things that I'm seeing, talking to foreign clients, talking to Indian clients, is that there is a lot more perception of risk in business. And therefore the contracts are trying to reflect areas of risk in a more detailed fashion. And that's one area where I think there's been a big difference between what was a pre-pandemic and a pandemic. From a drafting point of view, from a normal point of view, those are points which are always there. But if you look at contract as a risk allocation mechanism, why negotiations are taking longer, why it's getting complicated, because nobody wants to take that risk. It's always about bouncing the risk to someone else. I think that's where really the draftsman and the ability to control some of the narratives is becoming important in drafting of contracts.
And you're right, as Mr. Lalit Kumar and you, Mr. Badri Narayan, have said, also the last 17, 18 months have been stressful for businesses. There's a new context. We've dealt with something that we've never dealt before. So clearly, there may be, Mr. Lalit Kumar talked about the insurance companies looking at contract, but in a whole lot of areas, there have been situations that have arisen for the first time. So how do you deal with that? And I'm sure at some stage during the webinar, we'll get into it. But let me bring in Mr. Tariq Khan for his opening comments. Mr. Tariq Khan.
Thank you, Dr. Batra. My learned colleagues have already said and mentioned about force majeure because, of course, that was one clause which many people thought should be revisited and perhaps new factors should have been included. But I'll just limit this opening remark to arbitration clauses because what we have seen now in the past 17, 18 months, what has changed is that people have now started moving towards institutional arbitration because when they realized that COVID situation happened, the ad hoc arbitrations were all stalled and institutions were actively functioning and providing an excellent platform virtual. So due to that reason, it was very smooth to conduct arbitrations even during these tough times. And one more thing which I think now needs to be considered in all these dispute resolution clauses, because I personally feel that dispute resolution clause in any agreement is the heart of any agreement because like we know that disputes are inevitable in any contract. And at the end of the day, how you are resolving these disputes is going to determine a lot of other factors, how much money will be invested by a particular client and how much time will be spent in giving true meaning. Because it's not unknown to us that factors like what will be the seat, which court will have jurisdiction, etc., consume most of the times in any kind of dispute between two parties. So one thing which I think was not considered till now, and I think parties should definitely look at it, is that inclusion of virtual hearings as a proper mode and effective mean of hearing, because there may be prospective challenges to principles of natural justice that a party may say in 34 while challenging an award that, look, I was not given proper opportunity to cross-examine, or a fair hearing was not provided, or a virtual hearing may not be considered as a fair hearing. So these kind of prospective challenges may arise. Therefore, I feel that in a dispute resolution clause, if you are looking at, because we do not know how many different waves are going to be there, and if we want to stay and stick to arbitrations on a virtual platform, then definitely we must include in the arbitration clause itself that virtual hearings will be acceptable and they will be treated as proper hearings and fair hearings. That's the only opening remark I'd like to give. Thank you.
Thank you so much, Mr. Tariq Khan. I'm sure Ms. Joshi will join us. She's joined back. Ms. Joshi, your opening comments.
Taking a thread from what all of my predecessors have said, what we're really seeing now is a climate where we are testing the contracts. So we're testing the contracts on all of the issues that we mentioned, the risks, the obligations, and the dispute resolution process. So what has become important is the fact as to what the obligations are, whether they have been well drafted, how are we interpreting them? Because, there were, as someone else has also said, that there were circumstances that we didn't ever think would happen that have occurred right now. So we are trying to fit these unusual circumstances in the four corners of our existing contracts. So yes, going forward, of course, we're looking at our force major provisions in a different way. We're looking at a material adverse change provisions in a different way, and our dispute resolution provisions in another way. But how do we really look at our existing contracts has also become a huge part of a lawyer's daily life, and also, telling us where our pitfalls are, where we perhaps should have tightened the screws a bit, and have what would be a better practice today. So in a sense, as a practitioner, it's a great time to just make yourself more intellectual about these things, and also test them to see that our contracts remain workable and we're able to reach business type solutions, and how do we mitigate these issues when we're going forth.
Thank you, Ms. Joshi. I just want to say that, as I said right at the start, that this topic has had a huge resonance. Just on Zoom, we have 134 attendees, and overall, we have about 650 attendees between our social media platforms and Zoom. So it tells you, the reason I'm mentioning this number, it tells you that it's a real issue about contracts, as you rightly said, that they're being tested more now. Let me bring in Ms. Ashima Ori, who's the managing editor of BW Legal World, for the next set of questions and interaction with all of you experts. Ashima, all yours.
Thank you so much, Dr. Batra, and thank you so much, panelists, for sharing those valuable inputs. Now, before we ensure that our contracts and commercial contracts are set on a sound footing, I think it's very important to go back to basics for a bit. And for that, I would like to invite Tariq Khan to the floor. Tariq, can you please help us understand the basic structure of a contract to take this conversation forward?
Thank you, Ashima. Though there are learned speakers here who I think in a better position to explain, because in experience, I'm sure I do not have as much experience as my learned colleagues present here. But I think, yes, you're talking about going back to basics. So contract, of course, is one of the most important subject also. And I think it's very, very important in dispute resolution, because mostly, especially in arbitrations, what we see is that contract, it revolves around the contract. And the arbitrator also is a creature of an agreement. And within the four corners of the contract, he has to revolve, and then he has to pass a judgment. In fact, even in the court, not just limited to arbitrations, frankly, the contract plays a very, very important role. And what was the intention of the parties, and how they wanted the contract to be interpreted, and how they wanted it to be performed. These things are extremely important. And therefore, there are some basic things one has to keep in mind while drafting a contract. And yes, a contract may have different clauses, the most common being the payment terms, the termination, indemnification clause. But personally, I feel the most important clause one has to be very careful while drafting is the dispute resolution clause. Because at the end of the day, when disputes will arise between parties, you need to be extremely careful as to how you want to resolve your disputes. Often we have seen that parties, they try to put certain things which they are not even sure of, or perhaps they copy paste from the previous formats, and they're not really acquainted with the consequences that inartistic drafting or unconscionable drafting of a particular clause, not just the dispute resolution clause, that may have unforeseeable perils. So one has to be extremely careful about. So basic ingredients of a contract, I must say, if you talk about the basics, would be, first is the offer, of course. An offer has to come. And there has to be an acceptance, which is the second most basic ingredient of a contract. There has to be free, without any undue influence or without any coercion. There has to be a proper acceptance of the same. And the most important part of a contract is the consideration. So there have been cases where this itself has been a matter of dispute. But consideration plays a very, very important role, that what you are getting, something for something. So you have to be very careful when you're drafting, because a contract without a valid consideration is not a valid contract. then the intention of the parties.
Just to add to that, Tariq, for the students who may be joining us today, I think we always get asked this question many times: what is a valid consideration? Is it just money? Is it what all includes as a part of consideration? If you could just briefly mention that, that would be great.
Okay, so basically the first case of consideration was Curie versus Misa, wherein it was interpreted as something for something. And I think that's how they have been interpreting it, that there has to be some consideration. It has to be, it need not be adequate. It may be inadequate, but there are exceptions to consideration like love and affection, gratuitous act and trust. Probably these are things where you do not have consideration in return, but still they'll form valid contract. So it need not be necessarily monetary in terms, and anything which is, you are getting something in return, that is consideration. So that need not be adequate, and it can be something. For instance, if I am entering into a contract for a performance in a concert, so the consideration for that may be maybe some recognition that I'm getting, some publication that I'm getting with some magazine. So I don't think it need to be restricted to any monetary compensation. So that's my understanding of consideration. But moving forward, I think the most important part is that parties need to be very, very clear, lucid, and simple. The drafting needs to be in a very simple language so as to ensure that even if a layman is reading the contract, the terms that we've seen people using, whereof, hereof, thereof, and I think all of that, we should just do away with all of that practice that, because the contract is for two individuals who are not lawyers mostly, even though lawyers are drafting it, but we have to ensure that the language is super simple so that there is no ambiguity. Because if there is an ambiguity, then the issue that arises that for interpretation of particular clauses, you have to go to the court. And then it becomes a subject matter of litigation for years in order to give true meaning to those clauses. So I personally feel that use extremely simple language, which anybody who's not even a party to the contract, once he reads, the obligations of both the parties are absolutely clear. Because in any contract, the obligations of both the parties are defined. So they should be defined in such a simple manner that anybody who reads it should not have any iota of doubt. And there is no scope for ambiguity. I think clarity is what in most of our contracts I have seen is missing. And therefore, I say that when you are drafting a contract, especially the biggest issue has been the dispute resolution clause, because it's so poorly drafted sometimes. And even, one of the best, in huge matters, where the stakes are really, really high, like $1 million are involved. In spite of that, you're just not applying your mind in drafting an arbitration clause. And then sometimes the arbitration clause itself or the dispute resolution clause itself becomes a subject matter of dispute. And that itself takes years to, to get clarity. What was the intention of the parties?
Thank you, Tariq. You make a very good point there. And before I come back to dispute resolution and to you, I think I would like to invite Mr. Narayan to the conversation to help us understand the drafting of a contract from the scratch. I mean, we have boilerplate contracts, but if we were to put pen to paper right now, how would we start drafting? What are the considerations that you would take into account in the current time when we live in a virtual world? What are the things that have changed? And over to you, Rajiv.
Thanks, Ashima. I think, like I said, Tariq mentioned some very interesting and very important points. And I think those are points which are valid across pre-pandemic, post-pandemic, during pandemic. But when I am asked to draft something from scratch, and there are many unique transactions going on right now, and you're asked to draft this thing, how do you kind of get your mindset ready? One is to kind of immediately go and try and precedent. There is an art in selecting precedent itself, and I'll talk a little bit at the end about it. But let's say, for example, you've got a transaction, some family settlement, or there is a transaction which is unique in a digital world. How do you kind of think of this transaction? How do you kind of approach it? The first thing is that drafting of a contract is fundamentally different from all other legal documents. If you take most of the legal documents like pleadings, opinions, it's about convincing another person of your point of view. It's a persuasive document. But a contract is not a persuasive document. It's a document which reflects the understanding of the parties, both explicit and implicit. So then the explicit bits are what the client tells you, and the implicit bits are what you need to do. And then, of course, the safeguard that you need to put in place. Typically, whenever I approach a contract, and I can tell you from my perspective, but before I get into precedent, I typically kind of box the contract into three buckets. Okay. So the three buckets that I think of is what's the deal, how to perform the deal, and how to exit the deal. So the three real buckets that I kind of work on. So what's the deal is typically what the client will tell. Who are the parties to a contract? What's the term of the contract? Who's doing what? And what is he getting in return? And like what Tariq said, many times we miss the consideration bit. It almost becomes like a deed as opposed to a contract. Okay. So the first thing is to kind of get what's the deal. Okay. So you kind of talk to the client. This is what he wants. That part is something which is fairly easy to do according to me, because we're just talking and understanding. The last part, which is exiting the deal, which is basically what Tariq said, dispute resolution. A lot of our thought process tends to be on how to ensure that when something happens. So these are things like event of default, liquidated damages, termination, dispute resolution clauses, and so on and so forth. Again, a lot of material is there on that, and that's fairly simple and straightforward on some aspects. Of course, on dispute resolution clauses, on event of default, it can get very complicated, and you kind of have a lot of misses. And I always say keep it simple, keep it something which can be interpreted easily. That's an again. But as commercial lawyers, what I spend a lot of time is on performing the deal. Okay, the stuff which is implicit in the minds of the parties, but you want to kind of eke it out. So those are things like representations and warranties, covenants, condition precedents, remedies, okay, and indemnities and things like that. So those are things which you need to cull out by talking to the client and thinking a lot about it. So I typically allocate about 30% of my time to 40% of my time on the exit and the deal, but I spend 60% of my time trying to figure out what is it that the clients typically want. And that's really where I think realize the heart of drafting something from scratch, kind of allocating your time, having neat buckets. Representations, as you know, are statements of fact. So what do you want other person to say as a statement of fact? Covenants are what are going to be performed going forward. What do you want the parties to be bound by? Very complicated to draft at times. Condition precedents have their own issues. If you draft a condition precedent incorrectly, it can lead to a situation where the contract not getting closed. For example, I say I have to perform to satisfaction other party. Other party can keep saying it is not to my satisfaction. Okay. So how do you kind of find ways by which you ensure that you take care of these things? And then of course indemnities and so on and so forth. So those are things that I think I always focus on and kind of think of it in three buckets. As a first part being what's the deal? Really as commercial lawyers, not as litigators, where we come in is to kind of being able to eke out what is going to be the real risk coming out of the performance of the deal. And that's really where we spend a lot of time. Then of course, the exit. How do you find to ensure that if things go bad, how to handle that? So that's typically how I handle any contract which I have to draft from scratch.
But is there such a thing as an absolutely fair contract where both parties are equally protected?
I think that's a very good question. I think it's a utopian thought, okay, because no party ever is on equally balanced bargaining powers. So they're always different bargaining powers. Like I always said, it's an art in picking up a precedent. Let's say, for example, I do a loan documentation. Okay, the precedent that I'll pick if I was going with a lender will be different from a precedent that I'll pick up if I'm going as a borrower. If the borrower is a AAA rated company, he has a lot more bargaining power. He push the lender. Okay, if the lender is a AAA rated lender, he can pick a lot more. So if, for example, you're a lender and you pick up a borrower's precedent, you're in trouble. Okay. If you're a borrower and you pick up lender's precedent, so there's nothing like a fair thing. So ultimately you start somewhere. I think what, however, is happening is one area where there's a lot of jurisprudence is developing world over and also in India is this concept of good faith in a contract and contract performance. Typically, English laws never had this concept of good faith. Okay. You stand by whatever you enter into a contract. But more and more today in commercial transactions, there is a requirement because things are getting so complicated and people are taking advantage in unfair means. I'm not just talking about consumer contracts. I'm talking about real business deal. I think good faith is something which is coming into balance. So if, for example, you add good faith with some reasonableness, maybe there is something like a perfect contract, but according to me, that's a utopian concept.
Thanks, Prithvi, for that. And just to add to what Tariq also mentioned, language. Now, what are your considerations when you're making, multi-language agreements or even simplifying an agreement in English? What is, how do you go about drafting this?
So a few things I keep in mind, and this is almost like a checklist at the back of my mind when I'm doing it. First and foremost, I avoid nested definitions, or definitions are complicated. Okay, we have an ability as lawyers to make it like a if then else statement in a almost like a computer language. So you have one definition refer to another definition, refer to another definition. For a judge, reading 4 definitions to figure out what it means is the most frustrating and irritating thing. Sometimes we have nested definitions. One definition refers to another definition, which in turn refers to the same definition. So be very careful about that. Okay. Second, avoid non-obstante clauses as much as possible, notwithstanding what I have in para 8, okay, in clause 8. Then you have clause 9, which says not send anything in clause 9. So you have 2 non-obstante clauses, which is going to prevail. Big issue with respect to that. Then use third person, okay, when you're drafting, okay, rather than I, you, we. So you kind of use we and they, so that it kind of ensures that there is this thing. Use of active voice and passive voice has to be very clear. So whenever there is an emphasis on a person, you use active voice. Whenever there's an emphasis on the event, you use passive voice. So kind of making sure that you use that. Okay.
So do you have an example for that?
So for example, one classical thing which I keep telling is, for example, we say if any party terminates an agreement, okay. So the emphasis here could be on the party, or it could be on the event of termination. Okay. So if, for example, you drafted, if a termination were to be undertaken by a party, then the focus is on termination, not on the party. Okay. Same thing if you draft, if a party is to undertake termination, if any party were to terminate this, then the focus is on the party and not on the termination. So by using active voice and passive voice, you've been able to change what is the emphasis on which you want to be able to provide. So typically, especially in foreign contracts, you will see that when you want to bring emphasis on the party, you will use active voice. Okay. When you want to focus on the event, you kind of use active, passive voice and kind of move it around. And like the last thing that I always say is that the purpose of drafting a contract, there should be no leeway for interpretation. Therefore, everything should have only one interpretation, which both parties can come to. Okay. The whole purpose of litigation is that there are 2 interpretations possible, and both of us are fighting about what is the right interpretation, right? So ultimately, end of the day, because especially if you have multi-language contracts, you have to ensure that you write the language in a simple way. Like I said, I completely agree with Tariq. This here of, wherein, here and after, all of these things are extremely complicated. Other countries don't understand it. So for example, let's say a contract is going to be translated into Japanese, or there is a Japanese counterpart. Extremely important to kind of keep your contract simple, be very clear with respect to your communication. So that there's only one interpretation possible with respect to that. I've seen in some cases where our contracts, I've drafted some contract with French companies where I've written in English and it's been translated into French, and it has a completely different meaning. Okay. So being able to ensure that we are able to keep the same. So ultimately, your job as a draftsman is to ensure there's one only interpretation possible for your contract, and that kind of reduces litigation by 80%. So those are my thoughts with respect to this.
Thank you, Badri, and thank you for some of those really important points there on how you go about your drafting. I would like to now invite Mr. Lalit Kumar to the conversation. Mr. Lalit Kumar, I'm not able to see you at the moment.
Okay.
Yes, Mr. Kumar. Thank you so much for joining, and we would like to take this discussion forward. And I think another important aspect that has been touched upon is the exit, the termination, the breach. Now, what are your thoughts on drafting some of those clauses?
Sure. Thanks, Ashima. See, I think I quite agree with Tariq and Badri. Like, the contract has to be simple, contract has to be very lucid, and we should not use too much of legal jargon. All that is great, and all of us attempt to do that. But, the problem is the contracts do come to an end. There is sometimes very hostile termination of contracts. Sometimes it's very friendly. People are agreeing to solutions and situations mutually. And what I have seen in my experience is that most of the time, the termination clause in the contract is given least attention. At least in my long years of experience, I used to originally also do a lot of copy paste. But later on, I realized that we cannot write termination clauses just like copying it from one contract to the other. They play a very, very important role. and describing them in great details, because in the urge of closing a transaction, in the urge of completing things successfully, we sometimes tend to forget, or sometimes we are little casual when it comes to termination of the contract. Why termination is important? Because what if things do not work out well, and we say it's a hostile termination, or a termination because of a breach of a covenant, or someone did not fulfill their part of the duty, and then we are looking for clauses, because that is the time, and I quite agree with Tariq, that that is the time when people will land up in dispute. So imagine that things are coming to an end, nobody is aligned in their interest, people want to walk out, and the termination clause there does not facilitate the intentions of the parties, and we are in deep problem. So how do we resolve this? I think that we must focus, as we focus on our other, as I say, the facilitating part of the agreements, we must focus on termination. Now, the termination clause cannot be a vanilla, straightforward, straightjacket termination clause for all agreements. There are very, very different kinds of agreements requiring different kind of termination clauses. For example, if you are writing a services contract or an employment contract, the termination clause will be worded completely differently, because when an employee is terminated or leaves the office or the company upon resignation, what you would be interested in is he should not misuse any confidential information that he's got. He should not solicit the important employees of the company. He should not compete. If suppose, for example, you are terminating an employment contract of a major employee, you would say he should not compete with the company's business. He should hand over the documents. So you would write your termination clause and its consequences, because the subject matter of the contract is services or employment contract. Vis-a-vis, let's change the situation, and we are writing a termination clause for a shareholders agreement or an investment agreement. Now there, the termination clauses and its consequences will be completely different. So for example, if a party says we want to walk away in a joint venture situation, imagine it's a 50-50 joint venture situation and we want to walk away. Now, in that situation, the one party could say that we are walking away not because anybody breached it. Maybe we had difference of opinion in our approach and we want to wrap up our joint venture. So nobody is really at default that we can ask for compensation or things like call options and put options on shares. I mean, the consequence of termination could be that we will wrap up the joint venture company and distribute the proceed. Vis-a-vis, when I'm writing an investment agreement for a private equity investor and the company and the founders and promoters breach the contract, the PE investor would like to get an exit. So they will draft a clause saying if the company terminates or promoters do not fulfill their obligations and a situation comes to terminate the contract, they will like to put their shares, because for them the most important part is to get an exit as a financial investor. So they'll put the shares and want their principal money back, or whatever 2x, 3x, whatever return that they were promised. So I will word the termination clause of a PE agreement very differently. Just taking one more example, say we are talking about a technical collaboration agreement. A technical collaborator or a technical know-how provider will be most interested in protecting the know-how and the IP in the contract. So if the termination clause talks about all other things but does not lay emphasis on the fact that the recipient or the beneficiary of that technical know-how should immediately cease to use that technology, should not copy it, should not do reverse engineering. So my clauses will be worded suitably for that. What I'm trying to emphasize, Ashima, here is that when you draft a termination clause, you must first think through the kind of the agreement. I would urge all of you to jot down each and every situation, that what all could lead to termination, jot it down. As against that, please also jot down each and every event leading to what consequence. Don't jumble it up. I have seen agreements, believe me, in large transaction documents, in transactions and deals, I have seen a specific termination agreement running into same number of pages or fewer number of pages as any other transaction document, only laying out in a tabular form various situations describing if this leads to an event of termination, what will be the consequences. Sometimes the problem gets more complex than when you don't have only one agreement. You have multiple agreements and all the agreements are interconnected. I have done some transactions where there were 24 to 30 agreements. So imagine if one agreement is terminated, what will be the cross default or what will be the cross termination event? They also need to be thought through, and their consequences have to be thought through and clearly provided. So my bit on this is that please do not ignore termination clause. Please do not just copy and paste and borrow from last precedents or some other agreements. Every transaction, every contract is unique. It requires a very different kind of thinking to draft the termination clause and its consequences, remedies that you are looking for, damages or indemnity, survival provisions, which provision you would like to survive even after the termination is contract is terminated. So please do lay emphasis on this and just do not take it like a boilerplate clause towards the end of the agreement. This is what I would like to share. Thank you.
Thank you, Mr. Kumar. And to follow up that with a couple of questions, how exhaustive or watertight can a contract be, or a clause be for that matter, when you're looking at, you said a tabular form of doing what happens when, and in your experience, what is an ideal contract? How many pages does it run into?
Oh, see, it will depend, Ashuma. All this will depend upon the contract that we are writing. See, the tabular form that I was saying, that is not the norm. That is an exception sometimes when you have multiple contracts to handle. Imagine a joint venture situation. You have a joint venture contract. You have linked up services contract, which one JV partner will provide to the other. Some JV partner has provided technical know-how. Some JV partner is also supplying goods. So there are multiple contracts. So because when the JV, the mother agreement will terminate, naturally it will have cross default and cross termination effects. So therefore you would like to see what will be the effect on other agreements. So you may put it in a tabular form, but that is not the norm. I'm not suggesting that in all agreements you put a table describing it. If the agreement is only one, say a services agreement, you just need a very well-defined termination clause there. And to answer your question that how long is a typical termination agreement or a termination clause is, I think it is just one part of the agreement. In terms of pages, it might just run into 2 pages, 3 pages, sometimes even few paragraphs. So it's not that a full-fledged, only in situations where there are so many agreements that you would like to also have one termination agreement describing all situations at one place rather than every agreement talking for itself separately and independently.
Sure, Mr. Kumar. But again, in your experience, what is, how much importance would you give to a very descriptive contract, or, a brief and crisp contract? What is that actually is better for in commercial arrangements?
I completely agree with my colleagues here, panelists here, Badri and Tariq. The contract needs simplicity. I think the people who have to be blamed the most are the lawyers. Parties do not understand all the complicated contracts. Our job is to write simple contracts, simple, short, crisp sentences, plain English, and we must write what the parties are intending. I have seen clauses running into 50, 50, 60 sentences without even a full stop, without even a comma. That is not an ideal contract. An ideal contract is one which speaks less, speaks and meets the objective, simple English. I mean, the legal fraternity is used to expression like shall. The simple phrase to use in place of shall is will. Try using it. The other side counsels or other side, other parties just want the word shall back. In a normal common English, in a normal common conversation, we never use shall. But when we write contract, somehow we are used to using the word shall. So if you replace shall and try using will, for example, you will see how easy the contract becomes to read. But the problem is that the people who will see with the word will, they will replace it with shall, which is what Tariq was trying to mention, that we need simplicity in contract. So according to me, we do not need write repeated sentences. I have seen contracts where for first sentence, first paragraph, first provision is laid out, and then the second paragraph says, for the avoidance of doubt, it is clarified again. Same thing is again clarified. So I think you asked me that what should a look and feel of a contract should be. According to me, it has to be simple English language like we converse. I know there are commercial contracts, it's easier said than done, but our attempt should be this, that we should use simple sentences, clear language, and clarity, not ambiguous clauses. If you write ambiguous clauses, Tariq did mention, I do agree with him, that later on the dispute will be only to interpret what that clause meant. So therefore, the attempt should be to make smaller, shorter, and clearer and crisp clauses in the agreement with simple language.
And Mr. Kumar, like you mentioned, Shal, I think the same sword hangs on have, should have, must have, non-must have provisions. Now, how do you ensure that a contract is bereft of all these things put together, or how do you handle that?
See, this will be, Ashima, a cultural and a complete uh, change in the way lawyers think. See, we are the people who are supplying these contracts, not the business people. If the legal community and we as lawyers and professionals start using simpler sentences, even if you see the starting paragraph or starting thing when we write a contract, we say party of the first part, party of the second part, party of the third part. It's all irrelevant. It's not needed. We write recitals by saying whereas. These are all, I mean, if people have seen even a small document like power of attorney, it starts by saying, no, all the men present hereof. It's not required. It's all traditional, coming 100 years back. These were legal languages. We are evolving. So if you ask me, where do we start? The beginning has to be from the legal community. One another, we have to understand how people write. We have to accept it as lawyers, and then only the business people, commercial people, and the companies will start accepting. So if you will have hereof, thereof, I agree, Tariq said that, hereof, thereof, all this is, it's not required, without which the contract is simpler, easier, reader friendly. What he mentioned, and I completely agree with him. He said, when the dispute happens, it's not the lawyer who's drafted the agreement will be available to interpret. A good draftsman as a lawyer is one who drafts an agreement like a construction contract. If I've drafted, the person who is actually implementing the construction, the engineer, if he can understand, if she can understand the contract, I have done my job well. But trust me, it never happens. A construction guy, when reads the contract, gets more confused than he was earlier. So this is where we fail as lawyers. So therefore, the starting has to be, start using simpler sentences. I would urge people here, if I get in my contract, somebody has changed shall to will, I never object. I never object, because I am supporting that. But in reverse, people have not reciprocated. I know in transactions, when I've tried to make the language simple, the other side counsels become very jittery. Their clients become very jittery. That what is he trying to do? I'm just trying to make the agreement simple, nothing more.
I think that's the image lawyers carry, that there has to be some catch there behind changing those words in traditional practices. Thank you so much, Mr. Kumar. Now back to Tariq. Tariq, we've discussed the language part in detail, and we'd really like to come back to the dispute resolution. Governing law happens to be, in spotlight every time dispute resolution comes along. Also, now we live in a time where you mentioned live streaming could be a part of the dispute resolution clause. There is also mediation, arbitration, there is mediation, MEDAR. So what is your consideration, and in the practice of, commercial disputes, what have you seen working there?
Thank you, Ashima. And firstly, I'd like to say that there were really good inputs from the co-panelists. And I was very interested in knowing their thoughts, because they have a lot of experience and they shared some really good inputs. I'll cut it short because I think there's paucity of time. It's a long topic. But I think that the dispute resolution clauses, like we were discussing, that mostly we have seen that some people are in the habit, especially in the PSUs, we have seen that the previous formats of older contracts are being copied and pasted in huge projects, in infrastructure projects, in EPC contracts. I have seen some references to the 1940 Act. Even today, the arbitration has been, the new act came in 96. It has been amended in 2015, 2019, and recently in 21. But the reference is to the Act of 1940. which is not in existence, which has been repealed. So that shows the lack of application of mind and how casual we are when we are entering into a dispute resolution clause. We feel that it's just a formality, whereas it is in fact is one of the most important clauses. The other thing that I have seen is that in dispute resolution clauses, people are putting all disputes must be resolved by arbitration. Now, this may appear to be a valid arbitration clause, but it isn't, because the essential ingredients, the elements are missing. That who will be the arbitrator, who will appoint the arbitrator, what will be the language, what will be the seat of arbitration, what will be the scope of arbitration clause. All of these essential ingredients are missing. In some of the contracts, I have personally seen that there are blanks that have been left. The seat of arbitration shall be dash. And there is no way to interpret it. There's no way to understand what was the intention of the parties. The court's valuable time is spent, years it takes to ascertain what was the true intention of the parties. So I think these bloopers, these this inartistic drafting of arbitration clause needs to be corrected. We need to do away with this practice, because unconscionable drafting of an arbitration clause or a dispute resolution clause, it has unforeseeable perils, and a lot of money and time is spent in giving its true meaning, and the whole purpose of arbitration gets defeated, because you are just wasting your time in the courts. And then one party is saying, no, there is no arbitration clause, it's not a valid. But there were some observations from the Supreme Court in Visa International case versus Continental Resources, if I'm not wrong, where the court said that as long as the true intention of the parties is clearly visible, that they intended to go to arbitration, we will always refer parties to arbitration. So that's the approach which has been adopted recently. But I'll quickly and briefly tell you what are the things one must keep in mind while drafting an arbitration clause. You mentioned about the governing law. So of course, governing law parties need to be very careful while choosing which law will govern the main contract, because a lot will depend on that. Sometimes parties just casually put it that governing law shall be India or any, especially in international arbitrations. But you need to know what are going to be the implications of this governing law on your case. Sometimes parties choose seat without even realizing what is the approach of the courts of the seat. So you need to be very thorough and careful how the courts of that country have interpreted the term public policy, how narrowly they have been construing public policy, and whether they are arbitration friendly, whether they are enforcing arbitration agreements, whether they are enforcing awards, or they are trying to restrain or resist enforcement. So while choosing a seat, because seat I think is the most important aspect in any arbitration dispute resolution clause, you need to pay attention to the seat, because there's a lot of confusion. Mostly I have seen people using the term place or venue, though the Supreme Court has now clarified. There was a lot of debate. First, we heard Balco, Rogers Oshua, then Hardy Exploration, then equivalent bench overruling it in BGS Soma by Justice Nariman, then Mankatsu Impex. But what we have understood today, like Justice Nariman in BGS Soma clarified that, look, if there is nothing which is showing otherwise, then venue will be treated as seat, But the problem is in the amendments, we don't see the legislature addressing these issues. The seat has not been clarified till now. There's no mention of seat in the Arbitration Act. And the other issue is that seat is the epicenter of an arbitration. Everything revolves around the seat. If the seat is in Delhi, then Delhi courts will have exclusive jurisdiction on the arbitration. But what parties do? In jurisdiction clause, they'll put Mumbai courts will have jurisdiction. And in arbitrary dispute resolution clause, they'll write that seat shall be Delhi. So confusion over confusion again and again. So many judgments have come, Brahmini, Pellets, and then many other judgments wherein this concept has been clarified. So what I'm trying to say is that seat, you have to be very careful that the courts of the seat alone shall have exclusive jurisdiction. This is one thing you should always remember. And another thing I would like to point out is the scope of your arbitration clause. That always use the language. Most of the time people say that any dispute arising out of this contract. What you should rather use is that any dispute or differences arising out of or in relation to this contract or in connection to this contract. By using this phrase, you are expanding the term of the language. You're giving it a wider meaning that more disputes can be covered in the ambit of the arbitration. Because the purpose of an arbitration is one-stop adjudication. You cannot go if there are like multiple contracts within two parties. So far as one contract is concerned, you're going for arbitration, and for others, you are going to the court. It cannot be the intention. The idea is to have all disputes adjudicated under one forum, and therefore use this expansive language that we have seen in Chloro Controls, Amit Lalchan, how even non-signatories were referred to arbitration. But that is possible only if you use this wider expression, that in connection to or in relation to this contract. Another thing is that language is very important in international contracts, especially where you are entering into a contract with a foreign entity. In one of the arbitrations, the other side was a Russian party. The arbitrator was from Australia, and the expert was a French expert. So imagine if there is no uniform language, then the witness is deposing in Russian, the expert deposing in French. So everybody's speaking in his or her own language. So uniformity is the key. That's why English we choose, because the most common language. Another thing is that you have to be very careful when you're putting, because parties do not know what will be the amount of dispute, what amount will be involved in dispute. So you have to be very careful with your choice of arbitrators. Parties often ask me that whether we should go for one arbitrator or three arbitrators, because as per the Section 10 of the Arbitration Act, the number can only be an odd number. So the idea is that three people will have more fees. It will become more, inconvenient because the diaries are usually full. So go for a sole arbitrator when the dispute is not, very technical, very complex, and very, involving high stake matters. And if you are not certain as to how much amount of dispute will be involved, you can simply say that if the dispute is below X amount, then one arbitrator. And if it's more than that, then three arbitrators. That's one suggestion I'd like to give. Now, lastly, coming to the MEDARB clauses, I think it's a great practice nowadays. We have also seen ARB-MEDARB and MEDARB clauses. So MEDARB is basically that parties prefer going to mediation first. And then if mediation fails, then they go for arbitration. So initially they say that in case of any dispute, parties will first try to resolve amicably. And within 15 days or 30 days, if it fails, then they can go to arbitration. So you cannot invoke arbitration straight away. It will be premature. You have to first give an attempt to settle it amicably. So these are like very encouraging. And I think it's like promoting our mediation culture nowadays. So I think I strongly recommend MEDARB clauses. One last thing I'd like to tell is that go for an institutional arbitration, because it is always better than ad hoc arbitration. Because the problem with India is that most of our arbitrations are ad hoc. And I think that's where we are lacking. We are not becoming a hub of arbitration. Institutional arbitration makes it very convenient, smooth, and effective, so that you don't have to go to the court for every small little thing, like for appointment of arbitrators, challenge to the arbitrator. All of these procedural issues can be taken care of by the center itself. So to sum it up, I'll just give you some brief tips which I have pointed. One is that avoid vague references in your arbitration clause. Keep it simple and not complex. Do not use words like may, because when you say may, then it's about discretion. So either use, like rightly pointed by my colleagues earlier, use must, will, or shall. I mean, shall is what you'll be using, I'm sure. But specify the seats of the arbitration and know the approach of the courts of that seat. That's very, very pertinent. And institutional arbitration should be preferred. And if you are using an arbitration clause, go for the model clause of that institution. Like SIAC, ICC, they have their own model clauses. So use that. And choose a convenient venue and a language which is convenient to all. So that's my take on dispute resolution clauses. Thank you.
Thank you so much, Tariq, and thank you for beautifully summing that up for us and for our viewers. I'll now go to Akanksha. Akanksha, could you come in and take us through the interpretation of contracts? What are the courts saying about ambiguity, and like all the speakers have mentioned, language needs to be simplified, and there are certain kind of things to be avoided. Even then, everyone lands in dispute, and then contract enforcement is such an issue in India that it actually brings down our ease of doing business ranking. So, what are your thoughts on this?
Sure. So again, what the preceding speakers have said is absolutely correct. There needs to be clarity in the way that we draft, and the parties need to be in consonance with each other. They need to be ad idem. So what happens really is that if a contract is inarticulate, if it is verbose, there is more chance of there being ambiguities or inconsistencies in the document. And that would really lead to the courts kind of scratching their heads, thinking, okay, what do the parties mean? Because they were not there at the time that the contract was formed. Starting from what the Contract Act says, for a agreement to be valid, one of the requirements is free consent. I think Tariq had also mentioned it when he said it. And one of two of the factors which talk about free consent is that the contract should be free of mistake and it should be free of misrepresentations. So it's very important that the parties' minds meet when they're entering into a contract. And the other interesting sort of thing is an uncertain contract is void under the Indian Contract Act. So if, like again, Tariq's example that there was a seat or a venue which was left blank, or there was something where the courts just can't interpret it, there is still a possibility that the court could held that this contract can't be upheld because it's void for uncertainty. But the courts will always try and give effect to a contract. They don't want to say that the contract is void because they want to give the parties, parties' intentions effect. So we keep coming back to the point that it is all about intention and where do you get the intention of the parties. So the golden rule of interpretation is that look into the contract. You have to have a literal interpretation of the contract, read the entire contract in its entirety, and then you will understand what the parties meant, right? That this is the first principle. Of course, this doesn't always hold good because, all of us are not the best draftsmen. Lawyers and laymen, like, we enter into contractual arrangements all the time, and, sometimes it is not very clear. But the first idea would be to look at the document as a whole, and your surrounding circumstances don't matter. So, for instance, we've said X in the document, but the intention was Y. At that point of time, the court is not interested in what the intention was if it is contrary to what is there in the contract. So that is really where you go from. So a very interesting case in this matter was there was a rent agreement between a tenant and landlord in Delhi, and the tenant was a company, and they had actually taken on lease the premises for the purpose of residence of their directors. And the clause read something to the effect that it is for the residence of their directors or employees or other purposes of the company. Now the landlord wanted to actually evict the tenants, and it went under the Delhi Rent Control Act, where you only deal with those premises that are residential premises. And this was actually resisted by the other party on the basis that this one clause which says residence of the company, residence of the directors and other purposes of the company, meant that it was also meant for official or commercial purposes. It didn't really restrict us from having any other usage for the premises. So it's out of the purview of the Rent Control Act. So one thing that you needed to know is, of course, the law, what the Delhi Rent Control Act said. The second thing that you needed to know is whether the intention of the parties was to look at, only a residential sort of arrangement, or was it also to extend? So the court looked at two very interesting points when they came up with their decision. Number one, they saw a clause in the document which said that the tenant cannot install anything into this premises apart from cooking equipment and air conditions. On that basis, they thought that this means that they don't allow for office equipment to be brought in or any machinery, etc., to be brought in. So it could not have been the intention of the parties to have used it for anything else. So here you're looking at the literal interpretation of the contract rules, where you look at the contract in its entirety to try and figure out what the intention of the parties is. The second part was about surrounding circumstances. So generally, the courts do not look at past conduct, discussions that they may have had, or what has happened afterwards. But at that point of time, I think one of the submissions by the landlord was, there were certain declarations that were made by the director who was staying at the property, saying that this was only being used for residence, which was used for calculation of tax, municipal tax. So obviously, because that was being passed on to the company, they wanted to claim a lower rate of tax because of using it as a residence as against commercial premises. Looking at the surrounding circumstances, looking at all of those things, the court actually came to the conclusion that this was actually a residential property. So Here you can see how the court has looked at a clause which was ambiguous, looked at other clauses in the contract to try and give flavor and meaning to that, and also looked at the surrounding circumstances to come to what the intention of the parties is. So the point is, again, we need to be very clear about what our intentions are. So the parties, when they enter into a contract, especially when we're looking at very complex contracts, you enter into a term sheet, and then you enter into a definitive contract. So it's important for the parties to discuss and come to an agreement as to what they're expecting, what are the purposes and what are the obligations, and then correctly capture them into the contract. Uh, Having said all of this, there are also certain implications that arise. One is, of course, an implication by law. There are certain, certain I would say covenants or certain rights and obligations of the parties that the law implies. A very simple one is when you're buying any property, uh, or sorry, any movable property. And let me just clarify. The sale of goods act says that there is a warranty to title which is being provided unless it is accepted by law, accepted by the contract. So even though I may not in that contract write something to the effect that the movable property that I'm selling to you, I promise you that I have the right to it. I promise you that my title is going to pass and you will be able to sell this property. Because the law has a provision saying this, I can still rely upon it. So you may not just be confined to the four corners of the contract. You may also have to look at the law to see how you want to interpret it. The second thing, of course, is business efficacy. Now, business efficacy is a very vague term, but the idea is that the court, when it's considering a contract, is going to look at how it is a prudent businessman would look at this contract. How would you look at the surrounding circumstances given the particular business and the commercial circumstances? Another sort of interesting case was there was a construction contract, and in the clause there was just a description saying excavation, where in the payment in the services clause it was something to the effect of excavation of soil, murram, and sock, SOCK. Now, sock doesn't make any sense in the context. So what was proposed by the other side was that this means rock. So it was basically for excavation of rocks. The court considered this, but what they actually held is that it is very expensive to cut rock or excavate rock as compared to excavation of soil and mud, which is soft. So no commercially minded, prudent businessman would agree to the same rate of consideration payable for excavation of soil as compared to excavation of rock. And on that basis, they actually said that no, sorry, you can't really interpret this as rock because that is not something that a businessman would look at. That is not something that makes sense in the context of the entire deal at that point of time. So you look at surrounding circumstances and implications that arise from the law as well as trade and customs. Another like last thing I would like to give an example of is about customs and trade usages, because especially when you're doing trading contracts and you just have these tiny little indents, with words written which are very standard form. So you don't have the entire understanding of what the intention of the parties were as far as their relationships are concerned. There's a very old case, in the Calcutta High Court, where there was a foreign supplier who had supplied goods to an Indian dealer, which was based in Calcutta. And the whole sort of question was around whether you would actually look at them as a principal agent relationship. And that would mean basically the dealer was it's supposed to indemnify the foreign supplier, or it was just a one-time trade, so that kind of relationship didn't come in, and the commercial implications were different. Uh, the Calcutta High Court at that point of time looked into the trade and customs of that area, during that time, and what was being done and what were the obligations that were usual in those kind of mercantile contracts, and then came to the conclusion that this was an agency contract and the Indian dealer was actually liable. Just to keep it brief, I would just say look at the intention of the parties, look at the literal construction, and the idea is, especially in commercial contracts, to look at them commercially, to look at them as if you were a prudent businessman. So yes, that's how I like to sum up.
Yeah, Kanchan, before I take the many questions from our audience, I would, ask you one more question that relates to the drafters rule. So, have you seen that play an important role in how contracts are eventually interpreted by the courts, depending on which party actually drafted it?
So there is actually a case, Supreme Court case from about 10 or 20 years ago now. Yeah, about 10 or 11 years ago, which really has kind of cemented the fact that Indian courts do, give give importance to the drafters rule. And this was again a case where the banks had actually rolled out a VRS scheme for their employees in the early 2000s based on directions that the central government had given them. And based on that, there were certain terms and conditions. And one of the terms was that a person had to have about 20 years of service, and then he would be entitled to have access to the VRS scheme, and get a certain amount of compensation. Thereafter, there was an amendment to the scheme, and the amendment was to the effect that if you had 15 years or less of service, then you could have an additional 5 years of working and then claim the VRS as well. So a lot of people had opted in for the scheme, without that amendment having come in place. And the question basically was whether they could, have claimed extra years of service on the basis of that amendment, uh, because they were not aware of it at that point of time, and that. And how would you interpret the two of these things together? Whether they were supposed to be read together harmoniously, or whether they would be read in isolation. And the court actually found for the employee saying that they could actually claim an extra 5 years on the basis that the bank should have known what they meant when they had issued those terms and conditions. Since they had drafted it, the contract would be read against them. And the VRS scheme was contractual in nature, so which is why these principles apply. And that is why the rule of contra preferentum was actually upheld by the Supreme Court, and this was a fairly leading case in this aspect. But now I've seen that a lot of contracts have in their interpretation clause a language to the effect that the rule of contra preferentum does not apply. So I don't know how this question will be answered, but the question then arises is that can you actually exclude this rule by putting this in the contract and by trying to exclude this from the contract? So I mean, I'm not aware of any cases for this, but yes, that is also something that we will be grappling with at some point, or maybe some of my colleagues here have already grappled with in a dispute.
Thank you, Akansha, for leaving us with that food for thought. And now I would request all the panelists to kindly join us again on the floor so we can take the questions from the audience one by one. I will direct the first question to Badri. There's a question, Mr. Naran, how can we make a contract watertight to avoid any unforeseen circumstances and liabilities?
I think a good question. I think, like I said, I think there's no possibility that you can have a complete watertight mechanism. Okay, that's one way you should just keep in mind. There's always going to be some leak because you can never contemplate all the things that can happen in the future. I mean, everyone drafted force majeure clauses for years together. I don't think anyone thought of COVID and kind of thought about it. Like, a number of litigations that we are seeing is just unbelievable. Okay, and there are litigations on the fact that we have not used the word pandemic in the clause in force majeure. Okay, so it's not possible for you to kind of do that. I mean, the way typically I kind of do is, one is you first, like I said, when you're doing these representation warranties, indemnities, you do a first level analysis, what's likely to happen. I think one other way of doing it is then abstract some of that into your contract. So for example, when you take a force majeure clause, for example, one way is to specify act of war, earthquake and whatever, acts of God and acts of war and all of these things. But then you kind of have a clause which basically says there's something which is beyond the control of the parties, which is going to make the performance not possible. So you need to abstract it and you give examples. That's one way in which you kind of make the contract watertight. At the same time, you don't want to make it very complicated, because the more specifics you give, the more limitations you have with respect to general clauses. I think those are things that we should kind of think of. Very clearly, you must understand what's most likely to happen in this contract if it goes bad. What is the likely dispute which is going to come, and try and address that. Second is to kind of give examples of what are the types of things that can go wrong, but then to abstract it so that you're able to cover the general position also and the particular position provisions also. And then, of course, pray to God that everything goes well from there.
Thank you so much, Patri. I hope that takes care of Mr. Rohit Mishra's question. Next question is from Janvi Wade. How can we avoid lengthy contracts and include whatever we want under the contract? Since layman would not love to read 10 to 12 pages of contract, I would request Mr. Lalit Kumar to please address this question.
Yeah, sure. I wish that was possible. See, no matter how much we try to make the contract short, crisp, abridged, but that's not the reality. See, contracts do cover a lot of subject matter. Whether you take a construction contract, to concise a construction contract in 10, 12, 20 pages will never be possible. Infrastructure contracts. Employment contract, yes, because the kind of nature it covers could be just 3 pages. So it really depends. Everyone's attempt is to make the contract simple, short, but don't forget that in the process of making it concise, it should not be deficient also. So therefore, it must cover complete subject matter, because parties are writing that contract as a written document to interpret, to read when a particular situation arises in future. We will fail as draftsmen, as architects of that contract, that we did not contemplate, or in the process of contemplation, we thought it will make the contract lengthy and we dropped it. We'll fail in our duties. So we have to strike the right balance. Our attempt always is to keep it short and simple, but the reality is contracts run into pages, and they will run into pages, sometimes even hundred of pages. But that's the way, that's the beast that we are dealing with. So therefore, my suggestion would be that try to make it crisp, but try not to make it deficient also. And just 10, 12 pages sometimes is very, very, it's a distant dream, won't be possible anytime soon for sure.
I think it's a necessary evil to have more pages and more, clarification.
So Ashima, I just want to add one thing to what Lalit said. One of the things that I have tried is that you first draft the contract, you then move all the terms that apart from the main terms to an annexure. Now from the annexure, you start picking what are the terms that you really want in the contract and what you want to remain in the annexure. And then you'll suddenly find that actually there are lesser number of terms that you want to have in the contract. And then you kind of work and kind of see if you really want to keep that. And the stuff which is there, you kind of either you retain in the annexure itself, or you kind of make it as a part to the contract and you make it a part of it, so that the layman is able to understand and read the first part. The second part is something that are more important terms that lawyers probably will look at going forward. So just thought I'll add that to what Lalit said.
Thank
Sure.
you, Patri.
Also, I'd like to add one thing is that what I've seen is that there's a lot of redundancies in the contract that we see. So one famous example is we had a transaction where the other side was obviously not the law firm, and we sent a shorter contract, and what came back was about 30% longer. And of course, you get very alarmed when you see a contract. Oh God, there's so much markup. But when you look at it, there were changes such as, let's say, if in a clause it started saying it is clarified that. They would add the language for the avoidance of doubt, it is hereby clarified that, right? So it added no substance. It did not change the meaning of what we were trying to say. So, but it took us a lot of time to go through that. So it also took up a lot of time. And it added nothing to the contract, and it became more difficult and unwieldy for the other parties to read. Secondly, for some reason, some people think that putting the same thing in the contract in different places will make it more, I guess, like a stronger sort of defense for them. So you may see indemnities in 30 parts of the same contract. Instead of that, you could have just taken the main things or seen if there were repetitions amongst them, and added that as one clause, and that would have cut through a lot of clutter and also made it a lot easier to read and to interpret should there have been a dispute.
Thank you, Akansha. I think these are some of the bad habits that are going to die hard. Coming to lawyers, and like all of you have mentioned, it's something we should really ask our attendees to take home with them. That please simplify your contracts. Don't add verbose, unnecessary, adjectives to simpler sentences. And Tariq, I think the next question stems from what you had mentioned about different jurisdictions. So the question which has rolled up, one second, I'll come back to the question. In its exclusive jurisdiction clause in Mumbai, if the exclusive jurisdiction clause is Mumbai, but seat of arbitration is Delhi, which court would have jurisdiction for arbitration?
So Justice Bhanumati's judgment, Mankatsu Impex, answers this question. Section 11 petition was filed in the Supreme Court because it was an international arbitration. What Justice Bhanumati said, that once the seat is clear, the seat was Hong Kong. So any thing like, appointment of arbitrators, challenge to the award, only the courts of Hong Kong will have jurisdiction. The seat will supersede everything. The seat court will have the exclusive jurisdiction over the arbitration.
Thank you, Tariq. I hope, Anupam Lady, that takes care of your question. Another one from VM Raman. Whether indirect loss can be enforced only if such clauses are part and parcel of contract. Any insights? I open this to anyone who would like to take this question.
So by means, okay,
go ahead,
sorry.
Go ahead, after you.
No, I mean, so what I understand is that if there is no mention in the contract, still we can claim damages or losses. So 73 entitles you to claim damages. And I think section 73 is the answer, but I'd like to hear from my learned colleagues now.
Mr. Kumar? Sir, you're on mute, please.
Yeah, sorry, I was just trying to unmute it. So it's a good question. I think, there are two different aspects here. One is damages, which is section 73. 73 quite clearly says that you cannot ask for indirect losses and consequential damages and losses. So irrespective whether or not to provide in the contract, as per law, they are unenforceable. You will not get it. Sometimes people do fight saying that please write the word direct, please write the word direct in the definition of losses, because thinking that indirect losses will also get covered. Section 73 is quite clear as far as damages are concerned. However, for indemnity provisions, which is section 124 of the Indian Contract Act, such kind of a clear expression is not mentioned that indemnity can only be for direct losses. So therefore, if you want indirect losses, you could cover it through indemnity. But the important part of seeking indemnity is it must be provided in the contract. Unlike damages, even if the contract is absent of any provision for seeking damages, the law guarantees you that, or law gives you that right under 73, and you can seek that. So my suggestion would be, if you really want indirect losses to get covered, please provide it as the indemnity provision, and do specifically provide for indirect losses to be covered as indemnity. I'm hopeful you will get that, that clause will be enforced.
In addition to that, Mr. Kumar, I think another question which would be well addressed right now would be on capping of indemnity. So the question goes, would request the panelists to also touch upon indemnity and capping of indemnity.
Yeah, it's a good question. See, there's no legal statutory provision as far as this is concerned. This is more contractual. Parties are free to cap their liabilities and indemnity. And these days, in almost all the contract, even a simple services contract or even a professional services contract, you talk about any professional rendering services, their simple engagement letter will also say, should anything go wrong, the liability of the firm which is rendering that services will be up to the amount of the fee paid to them, or twice the fee, or thrice the fee, whatever is commercially and contractually agreed. So therefore, should you want to cap, and I would suggest, if you are writing a contract where you are the indemnifying party, which means you will have to pay the compensation should you get a claim of compensation from the other party, I would suggest to please put the cap. And the standard norms in various agreements is the value of the contract. Sometimes it is 150% of the contract, twice the value of the contract. So that can be commercially agreed, and that is legally enforceable also if you cap it. But if you are the person who is the beneficiary of that contract, which means the indemnified party who will claim the compensation, please try and push the other side back and don't agree to any cap. But legally, you can do that provided you provide that cap in the agreement. Also, you can provide the cap on the limitation in terms of time. You could say, you can only raise the claim after 3 years or 5 years, and that is put in the contract. If the claim is raised after that, maybe that will not be enforceable, and that will save or protect the indemnifying party from, covering the clause or bearing that loss.
I just want to add only one point, I think, and to Lalit, is that sometimes I find that clients, once they've got this limitation of liability, they think they are got scot-free. So many times they come and say, "Acha, mujhe to acha mil gaya, limitation of liability mil gaya. Ab I'm all done," and this thing. So one thing is that, fraud and gross negligence are still not something which will protect you. So those are two things that you need to be careful about. So willful misstatements, fraud, gross negligence, you don't take adequate care. Still, there are cases where the court will go around this limitation of liability and award higher amount. So I think that's something we need to be careful about. It's not like the battle has been won the minute you got this limitation of liability clause.
Thanks for adding, Badri. Thanks for adding. It's a very, very vital and important input. Thank you for adding this. Yes, I agree with you completely.
Thank you so much, panelists. We do have many questions, and I did set aside extra time for the Q&A, but I think we're going to run into a complete hour if we take every question. I would request the panelists to, answer them as we send them to you, and then maybe we can publish these on our website for our viewers to, understand how, or, see how they've been addressed. But before we close, I think I find a very interesting question, which is a little different from all other questions we have. Can you please tell us what is the scope of drafting as a career? Just drafting alone as a career. And the three things they've asked is salary, workload, and scope. So I think if all panelists could take this one by one, starting from Akanksha, that would be great.
See, drafting is a part of what we do. I don't think we would say drafting is all that we do. So, it's a bit difficult really, because you start, of course, with drafting, and then you move on to sort of, negotiating contracts and, giving advice, etc. So, at least I'm not aware of in India having a career which is exclusive to just drafting. But of course, my colleagues can be advising you better on this.
Thanks, Akanksha. Mr. Narayan, your thoughts?
I think first time I've been asked this question, and I think, like I said, it's a very interesting question. To be honest, I really don't know. I think all of us start as being draftsmen, but aspire to be a little more, either as litigators or as negotiators, or as ultimately we want to be advisors. I think maybe in the future, there's likely to be, especially with this work from home, and there being a lot more of freelancing, which is there. And I think that's definitely an area where there is a lack of good draftsmen, because, as you know, every 2 years, our associates want to become, they want to be managing a team rather than kind of doing the draft. But there could be people who are just interested in the drafting and get better at it. I really think that a lot more of the career is probably going to be in-house in the future. I think where you probably will have a requirement to have somebody manage a lot of contracts, especially in certain sectors. So I think that could be one area where I can see that. And I think another area probably is where this legal tech is coming up, where a lot of this is going to be looked at. And maybe somebody who's got a career in drafting is someone who can really help in kind of putting some of that in place. Those are things that I have. Workload. And this thing, once you choose law as a career, I think to then expect a lower workload is not a fair choice. And of course, compensation varies from person to person. So that's what I would say as an answer.
Thank you so much, Patri. Tariq, over to you.
I think because as a lawyer, it's very important to have good drafting skills. And I personally have taken up assignments in the past. But it completely depends what kind of knowledge you have in a particular field. Because for drafting something, you need to have the basic idea and good command over the law. For instance, if somebody tells me to draft a claim, then I need to know about the Contract Act, what kind of damages I can pursue, how I have to draft it. So if it's about drafting contracts, that's one thing that a lot of firms are doing. And yes, generally the juniors and the people who are just starting their career, they're given all the drafting work, because that takes a lot of time. but the workload is quite a lot. And I know quite a lot of freelancers who are doing this work. And I think it has a bright future, because not many people want to draft. And if they find people who are competent and capable, and if they have faith in such, individuals. So I think this reduces a lot of workload and shifts it to those people who are doing this job. But yes, the deadline, for instance, that I was given in one of the assignments was in 1 week, I had to draft a statement of defense, which ran into like 350 pages. It was a huge matter, and I had to read a lot. There was like sleepless nights, but yes, the amount of money that you get was pretty decent. And I think it's a great experience. So whenever you are drafting, you first have to read on the law quite a lot. You just cannot draft it and later on during arguments apply the law on that. From the day one, you have to assess that what will be my arguments, or the arguments of the counsel in the final hearing, and accordingly you'll have to draft your pleadings. So drafting, in my view, like research plus drafting, both skills are required. And if you have that kind of expertise, then I think it's a great career option. And yeah, I mean, that's the way I think.
Thank you, Tariq. Thank you so much, Mr. Kumar, for your comments.
I would have the same views as others have expressed. You cannot have a standalone career. You want to be a lawyer and then you say, I want to be only a draftsman, I'll draft and do nothing. It's very incomplete career as a lawyer, and is also not prevalent really. But if someone just wants to be a draftsman, wants not to review structured transactions or put opinions, or negotiate, as Akanksha said, then I think one window which is open is that in many companies, especially in law firms, there are knowledge management teams where they keep improving the documents. They have standardized agreements, new agreements keep developing. So you can join one of those knowledge management team, whereby they are only given the job of drafting and putting newer things in the agreements, keep revising, improving them, so that the deal team has a more established set of precedents with them. So your job will only be to help and draft. But then in that case, you won't be a full-fledged lawyer, because then you will be a back-end lawyer helping the lead lawyers or front-end lawyers. So that one option is there, and compensation will depend on what the need is. And I think fairly it will be good and fine. But to choose a career as a draftsman, I would say it's good, but not the best.
Thank you so much, Mr. Kumar. And my own 2 cents on this is that I do know of a lot of people in the freelance market who've taken this up, as Tariq also mentioned. And as Badri mentioned that, in the legal tech market, there is, the scope is increasing for people who can write contracts and review them, and also proofread them once the software has done its job on the contract. So it is an upcoming market. Maybe we'll see more people, but yes, you cannot dispense with the knowledge of law. So I think time will tell if it becomes a standalone career. But I think in work from home opportunities, this is something that can be explored more. So with that, we'll take your leave, and thank you so much, panelists, for sharing such valuable time and inputs today. Thank you for being with us for over 20 minutes plus, and thank you once again for being with VW Legal World today.
Thank you, Ashima.
Thank you, Ashima. Thank you, everyone. Thank you very much.